Good morning, everyone. Thank you for attending our online webinar today. Our topic is going to be non-compete agreements and employee contracts, what every business owner should know before it's too late. Again, I'm Kristina Wilson, the owner of KEW Legal, and I am going to be your host today. So a little bit about our firm. We are a full-service law firm. We are focused on delivering effective solutions for our clients. We have a range of practice areas that we serve. Our hope is to provide clear, straightforward counsel and ensure every matter is handled with precision and professionalism. We represent entrepreneurs and business owners, and our job is to make your life easier, offload your legal headaches and your exposure, your issues, so that you can stay focused on whatever it is that you're doing, whether that's investing in real estate or managing a business or trying to acquire a new asset. We want to make your life a little easier. So you can see a little bit of our practice areas: real estate, corporate and business law, general counsel services, are our main service areas. So let's get this party started. A little bit about me. Again, I focus my practice area on general counsel services and corporate law. I represent investors, developers, business owners, and all sorts of transactions. Been doing this a long time, especially down here in South Florida. Anything from corporate formations to drafting and negotiating contracts, complex business transactions, asset purchase agreements, shareholder purchase agreements, just a variety of different transactions. I have a background in business. I have an MBA in finance and also obviously a law degree. So it's a unique blend of skill sets that help me relate better to my clients. I am licensed in Florida, New York, DC, and Texas. All right, so today's agenda, the main areas that we're going to talk about is, what is a non-compete agreement, learning about the types of restricted covenants that are out there, the do's and don'ts of non-compete agreements, employee contracts, legal must-haves, things that you want to make sure that are included in those contracts. We're going to talk about a couple real-world applications here, a couple cases that came out on these topics, some best practices for employers, and really why you need to, reach out to an attorney when you find yourself in one of these situations, just to make sure that you're ticking all the boxes and protected in the best way possible. So to start things off, what is a non-compete agreement? So a non-compete agreement restricts an employee from working for a competitor or starting a competing business. What you're trying to do is protect your business interests. That secret sauce to your products, your trade secrets, the confidential information, what makes your business unique and special. That's the information that you're trying to protect from getting out there to the rest of the world. If you want to think of it, the most commonly used example that I've heard over the years for a trade secret is Coca-Cola's formula. There's a dozen different sodas out there, but when you taste a Coca-Cola, that taste is very specific and identifiable, even though it's the same color as other brands. It comes in a similar container, it's sold in the same places, but when you're tasting that Coca-Cola because of that unique formula that they use. And you can imagine how important it is to that company to protect that formula and make sure that the employees that have access to it are, holding up the highest due diligence and care when they're accessing that information, because that's what makes Coca-Cola special. It is typically part of a broader employment contract. You'll see non-compete language embedded within employment agreements or other types of contracts. To be enforceable, the restrictions must be reasonable in time, geography, and scope, and tied to a legitimate business interest. Okay, in Florida, statute 542.335 governs non-compete enforcement. So types of restricted covenants, non-solicitation clauses. Okay, these clauses prohibit an employee from recruiting a company's clients, employees, and contact lists upon leaving a company. A confidentiality agreement protects trade secrets and sensitive business information. We talked about that a little earlier with the Coca-Cola formula. IP assignment clauses ensures that an employer owns all the work that an employee creates during their employment. So if you have an employee that's working for your company and it's, their job to come up with new ideas and to make something, whether it's a product or maybe it's a method about how something is done, making that better and making it more efficient, making it different than the competition. That intellectual property, the employer is the one training, providing resources to the employees so that they can create. And so that fruits of that labor belong to the employer because it's, but for the employer investing in the employee and providing them the workspace and the financial, resources to produce that product or method or idea would not have been created. So the IP assignment clauses ensure that whatever's created by an employee during their employment belongs to the employer, and protects their investment. A non-disclosure agreement prevents disclosure of confidential or proprietary information. You'll see these clauses very often. Sometimes they're their own standalone agreement. Sometimes they're embedded within other contracts, but that language is very specific as to what is proprietary, what is confidential. That term is normally defined within the contract. And then, of course, there are some exceptions of when that information can be disclosed and what rules or under what parameters that information can be disclosed. All that language can be kind of negotiated and crafted as well to some extent. So the dues of non-compete agreements, we want to make sure that they're specific, all right? Because at the end of the day, people need to be able to work, right? We need employees, whether they're with your company or they move along to somewhere else, people need the ability to provide for their families, generate income, find another job. And so really what the non-competes are protecting is that we're looking for specific activities, right? We're looking for things that we want to prohibit, the employee from doing. So again, these kind of agreements are supposed to be geared for a certain type of employee that has access to the secret sauce or what makes that company special, or a large investment has been made to train the employee. Again, this is not supposed to be for an employee, for example, that runs a cash register at one business. You can't prevent them from going and running a cash register at another business. If they're flipping burgers at one restaurant and they walk across the street, start flipping burgers at the other restaurant, that's not the intention of a non-compete. Non-compete, again, it's for, your highly technical employees or the ones that have access to, again, proprietary information, customer lists, like highly developed things, scientists, high C-suite level people in a company, things of that nature, or where a specific amount of training has occurred to get them up to speed to be able to do their job. So we're going to define the prohibited activities. We're going to clearly lay out specific types of activities the employee is restricted from engaging in. So again, if they leave one employer and they're going to a different employer to do a different job, that's not really the issue. The issue is more if they go and do the same exact job that the prior company has invested heavily in them in. That's what we're looking to prevent. The limit and geographic scope, this is to ensure the restriction only covers the area where the employee operates and has legitimate business interests. So again, I've seen non-compete agreements, employment contracts with non-compete language in it that's talking about, you can't work for the next 10 years of your life anywhere on the planet. Again, the broader that is, the harder it is to enforce because, on its face, it kind of looks unreasonable. You have to show that job was so special and unique that geography is really irrelevant. It's really the service that you're trying to protect, but anywhere they're located, if they were to provide that same service, would be a damage to the company. So generally speaking, for most business owners out there, if you have a sales guy or something like that you're trying to limit, where they've had like an exclusive hold on a particular region. You're not trying to ban them for life for being a salesperson somewhere else, but maybe in that geographic scope for a certain time period would be deemed reasonable. So just keep that in mind when you're crafting these agreements. If you want it to be enforceable and upheld by a court, you need to make them as reasonable as possible. And it's got to be tied to a business interest, right? It's got to protect things like trade secrets, goodwill, or customer lists. Give consideration. In some states, continued employment alone may not be sufficient. Employers may need to provide additional value. For example, you are giving someone an extra fee or bonus or something, an exchange of something of value is going to that employee in order for them to sign this agreement. It's a contract like any other contract. So you need that offer, you need the acceptance and a consideration, which is that change of value. Exchange of value, sorry. Some don'ts in non-compete agreements. Again, we don't want to use a blanket non-compete. You want to limit them to the employees with access to sensitive information. It's not, someone that's on the, front line packing boxes or running the cash register, or, again, someone that doesn't have access to sensitive information. We're trying to protect the company's secret sauce. They're what makes them unique from other competitors. So if that employee doesn't have access to that information, really, this shouldn't apply here. Don't overreach with length or geography. Restrictions should be tailored to the actual business operations. For example, if you only operate in the state of Florida or a particular region in the state of Florida, don't throw in non-competes that ban someone from doing this in the entire United States, for example. Like, allow them to work, travel somewhere else, and do a similar job, or they can work within the geographic region doing something outside the scope of what they did at your business. Don't use vague definitions of competition. Courts will strike these down as they'll strike down unclear terms, or at best they'll go in and modify them to make them reasonable. So, just try to keep things very specific so that both sides kind of know what they're getting into, and it's not open to interpretation. Don't ignore state law nuances. Again, this goes for all my business owners that are downloading stuff off the internet and trying to stuff it into their agreements because it sounds official. Again, a lot of this kind of area of law is governed by state law. So that means the rules vary from state to state. So you need to make sure that you're compliant with your state and how they enforce these kind of rules. Otherwise, you're going to find yourself in a bind. And when you're going to a contract because something happened in your business, that's when you really pay the price for not having legal counsel, or for trying to use, Google as your lawyer, or ChatGPT or something like this, because it hasn't been crafted to protect your business. Don't violate public policy. Agreements are overly restrict an employee's right to work, may be unenforceable. Just keep in mind, put yourself in their shoes. They got to be able to pay, make a livelihood for their family and pay for their bills and all those things. So just have that in mind when you're crafting these agreements. Employee contracts, legal must-haves. So if you want to gain a long-term employee while avoiding legal battles, your employment contracts should include the following. We want to make sure that we have, obviously, we're going to reference compensation and bonuses and benefits. You're going to have termination conditions. You can have with cause or without cause, depending on what state you're in. But what that means, for example, in the state of Florida, we're in an at-will state. You don't necessarily need a specific reason to terminate someone here. You can terminate them for any or no reason, but you do have a burden as an employer to show that it's not a discriminatory reason. So you need to be able to show, in the event that's challenged, if you don't give cause, that it was not for a discriminatory purpose. So just keep that in mind. And then obviously you have dispute resolution processes that could be in there. And we've seen these, a variety of these over the years as well. Anything from enforcing mandatory arbitration or mediation. You can select jurisdiction. Obviously you would want to make sure if you're on the employer side and representing, a business owner that it's, where the business is located. You may pick a jurisdiction that's more friendly to business owners. So a lot of things could be factored into why you pick one jurisdiction over the other. Especially for a business owner that's located like throughout a state, there may be one county that's more business friendly than the other, or maybe you have a bigger footprint in one area versus the other. So you go that route. IP ownership language, again, that's very, very important, making sure that the employee knows whatever they produce while they're working does not belong to them. It belongs to the employer. Your restrictive covenants, if applicable, compliance with any applicable state or federal law, and your acknowledgement and signature sections, all your boilerplate language, all that stuff. All right, let's talk about a couple of examples here. So we're just going to bring up a couple different cases that are on this topic, but just want to bring your attention to how the court enforces or interprets different scenarios. Here we have Sunder Electric filed a lawsuit against its former head of sales and affiliate entities, Freedom Forever, Solar Pros, and Principals, and some other individuals as well. So basically what happened was Jackson met with executives from these entities, and shortly after he began recruiting Sunder sales, the teammates of the sales team to the competitor. And within days, 9 senior managers and over 300 sales reps had transitioned to Solar Pros. So Jackson then signed a consulting agreement with the company. So in 2024, the Delaware Supreme Court declined to enforce Jackson's non-compete agreement. The court held that the restriction was unreasonably broad, giving Jackson's role as a minority non-voting member of the LLC. The agreement was also deemed invalid due to a complex and one-sided language, as well as the minimal consideration Jackson received. So the problem here is, like, if you're the business owner of Sunder Energy LLC, you just lost a big chunk of your company, and you're doing what you can to protect your business so that this kind of thing doesn't happen, and your key employees or star employees don't get poached over to a competitor, because you spend all this time and money training your employees, and you're doing that so that they can represent your company to the best of their ability. You're empowering them with tools. So you want to make sure, it's so important that you have someone look at these contracts, because again, if your contract is vague or overly broad or something like that, and it's deemed unenforceable, then what you're trying to protect can be, you can lose the rights to that. And that's not what you want as a business owner. So don't make these mistakes. Make sure you have, non-compete agreements that are reasonable in scope and easy to comprehend, your non-solicitation and all that. Make sure that you're giving, a proper consideration as well. If you're just presenting your employees with a non-compete or non-solicitation, and you're not fairly compensating them for them giving up those rights, then there's a chance that it could be deemed invalid, and you're going to be left exposed as a business owner. So it really just is not worth it. Okay, so Rulex Co. LLC versus Telstream Inc. So Rulex had engaged Telstream as a subcontractor under a master service agreement. The principal of Telstream, Carney, executed the MSA and a separate non-compete in February 2016. The non-compete restricted post-termination competition and solicitation for 24 months within a 200-mile radius of the locations where Carney had performed services. So he worked for Rulex until about, middle of 2017, and then subcontracted with a direct competitor of Rulex, prompting Rulex to file suit for breach of the non-compete agreement. So the court declined to enforce the agreement, holding that it lacked adequate consideration. Again, Carnice signed the non-compete after beginning work and was not provided any new or separate consideration at the time of signing. So they found that the agreement was unenforceable. So again, this is one of those things that if you're doing it separate and apart from when an employee comes on board, you've got to give them separate consideration. If you do it at the time of employment, like when they're first coming onto the company, you can make the argument as a business owner that the employee's employment was offered based upon them signing that agreement, and that consideration, generally speaking, would be held enforceable. But if you wait and you do it later, the employee onboards, and then a couple months later you present them with this non-compete, you have to give them separate consideration. And as we learned in the previous case, that consideration has to be reasonable. It can't just be, some minimal amount. It has to be worthy of what they're entering into. So takeaways. You want to make sure that your non-competes are signed at or before the start of employment. You want to avoid one-sided restrictions or broad restrictions. They're often struck down by the court, and you always want to provide sufficient consideration for enforceability. Some best practices for employers. Again, navigating, the complexities of non-competes, it can be tricky, especially over the last couple of years. There are some best practices to ensure your agreements are enforceable, fair, and tailored to protect your business interests. You want to make sure that you review your state and federal laws to make sure you're aware of what your state deems reasonable and what they're finding enforceable. Again, there's been a lot of news out about non-competes over the last couple of years. In April 2024, the FTC, the Federal Trade Commission, issued a final rule largely banning non-competes with the exception of senior executives and the sale of a business. And this rule is currently subject to legal challenges in court, so it's being actively challenged. So employers should also monitor these updates as they roll out. Make sure you're reviewing all your agreements annually. Tailor your contracts to business model and industry standards. Use layered protection, not just one clause. You want to make sure that you're protecting things multiple ways. If one falls, you've got others that you can rely on that may kick in. And again, very important to seek legal counsel here before hiring a competitor's employee and when drafting non-compete agreements. We also get called quite often where we have an employer that's hired an employee and, they've trained them, they're off and running, and then 8 months later, they get a nasty letter written by one of the employee's prior employers trying to enforce a non-compete, and they're having to go through and sometimes we've seen where the employee unfortunately has to be let go from the new employer because there is a non-compete in place that is reasonable, and it's a cost benefit analysis to fight these kind of things for the employer, and they have to make a decision. And then we've seen some where the former employer is just trying to impose a very broad, very vague, overreaching kind of non-compete, where the new employers decided to take a stand and challenge the enforceability of that agreement. So why do you need an attorney? With the introduction of the new FTC rule, again, it's more crucial now more than ever for businesses to seek some legal advice here because the law has changed and it is being scrutinized. So we want to make sure that you're up to speed and your contracts reflect that, and to be able to navigate the changes and ensure that your business interests are protected. Again, an experienced attorney will draft enforceable contracts tailored to your business needs, explain the changes and the developments as things are kind of rolling out to you. Protect your business from inside and outside threats. There's a variety of ways to do that, not just contracts, but different protocols and procedures that you could put in place depending on what the scenario is. reducing the risk of lawsuits and regulatory violations. Again, that dispute resolution, in the event something like this does happen, how do you resolve it? And you want to do it in a way that the employer understands, so they can manage their budget and have that in mind, if something were to arise. And again, an attorney will help you stay updated on the evolving FTC rules and state laws as they roll out. How KEW Legal can help you. Again, if you're a business owner or even an employee in some circumstances, but primarily a business owner, and you need assistance with reviewing a non-compete or drafting a non-compete, we are here to tailor agreements to your industry and ensure they're compliant with the statute that applies, and making sure that they're protecting your business. Risk prevention, identifying potential weaknesses in existing contracts that could expose your business to disputes or litigation. Obviously, we want clean contracts. We want everybody knowing what they're entering into, what they're signing, that they understand their obligations to the company or to the employee and vice versa. So this is pretty important. Employee contract guidance, structuring employment agreements with clear job duties, compensation, termination, terms and conditions that reduce risk, anything that is unique to that employer, things that they're trying to protect against. All that kind of language is also crafted and embedded in there. Dispute resolution, representing and advising you in cases involving restricted covenants, employee departures, or alleged breaches. So we constantly get calls from our business owner clients about what to do because this employee's gone rogue and they're taking company property, or they're hacking into the system, or they're reaching out to our best clients or our employees. So it's really kind of trying to be proactive and putting things in place to prevent, but the reactive part of, in the event something like this were to occur, what can you do about it? And that's what we're here to do. We're here to help you along that path because it can be very stressful when you're in that situation. And then compliance monitoring, we want to keep you up to date of the changes in the law and any administrative laws that may impact you as a business owner, especially the one that involves non-compete agreements. So again, if you have any questions about this webinar or this topic, please feel free to reach out to our office. You can schedule a free consultation with us. You click on that QR code or call our office number, and we'll be happy to assist you. Thank you very much for attending, and we look forward to seeing you at our next event or webinar. Have a great day.